All right, I'd like to call to order the Town of East Troy Planning Commission for the month of February. I'd like the record to show that all the commissioners are present with the exception of Commissioner Gordon, who is replaced by Commissioner Russell. How we work is we work on a split meeting format. Tonight is our informational meeting where we will gather our information on any applicant. What we will do is have the applicant come up, make their presentation to the board. We will have any questions from the commission to the applicant. They will sit down. We will then open it up to the audience after that, and we would have anybody in the audience who'd like to speak in favor of the proposal, and then anybody who would like to speak against the proposal, and then, if necessary, a short rebuttal from the applicant. What we do then is we adjourn for 2 weeks. We come back and we have our decision-making meeting in 2 weeks. That being said, that's not by ordinance, so if we feel it's straightforward and we could make a decision tonight, we would make it tonight. First item on the agenda is to review and approve the Plan Commission minutes from December 4th as well as the 18th. Anybody see any issue with the minutes?
Yeah, I think there's a typo in the minutes for December 4th. I pointed this out to Jen earlier. So item 4, on the top of the third page, if this request would issue the easement, I think it should be affect the easement. Minor typo.
Okay.
Other than that, everything looks good to me.
Anybody else have any concern with the minutes? I would take a motion to approve with the amended typographical error.
I'll make a motion to approve the minutes of December 4th and December 18th with the correction noted.
We have a motion. Do we have a second?
I'll second.
All those in favor? Aye. Opposed? Motion carries. Next item on the agenda is rezone / conditional use. Sent back to, this is not sent back to the Planning Commission. It's a conditional use. West Ridge Cottage Industries, N8828 Stringers Bridge Road. Parcel PET 1800006A.
Good evening. I'm a couple days into a good cold, so if I'm not real talkative tonight, just bear with me. All right, we started off back on June 6th in front of this board here, and we took up the rezone for this property here. And 10 meetings later, and with the approval of the full town board and the majority of the town board and the unanimous decision at the Walworth County CZA board, and subsequently the full county board, we now have the property in C2. And here is my declarations page, amending the ordinance, showing that the property is C2 now. So we're coming back now, and we're doing the conditional use portion of this. And leading up to this point right here, I've had about 5 or 6 meetings, lengthy meetings with both Darren Schwenke and Kate Hastings at Walworth County. And we went over everything in great detail, what is allowed, what isn't allowed, what they expect of you, what they don't expect of you. And in doing so, I was able
I'm
to
sorry,
have.
can I interrupt real
Sure.
quick? I apologize. I didn't give
Yeah.
Commissioner Janner, he needs a chance to say something.
Yeah, no
He's
problem.
gonna recuse himself.
Go ahead.
I apologize, totally my fault.
Given the training on quasi judicial proceedings that I received in January from Jim Mills, it was under advisory that I recuse myself from this because it is a conditional use. So I'm going to recuse myself from the Planning Commission vote.
Thanks. All right, sorry about that.
Oh, no problem. So subsequently, after several meetings out at the county with Kate Hastings and Darren Schwenke, our zoning officer, I was able to have my application, which was turned in, and it's in your packet, with Kate's initial on there. So basically, everything that we're trying to do here today is compliant with what's in the county zoning book. So on this conditional use, I am going to comply to all federal, state, and local laws and ordinances that relate to the granting of this conditional use. So, I want to read something here to the board. This is an Act 67 memo, and basically, it says the act requires a city, village, town, or county to grant conditional use permit if an applicant meets or agrees to meet, which I have and I will, and I do, all of the requirements and conditions specified, relevant ordinance, or imposed by the relevant zoning board. Any such conditions must be related to the purpose of the ordinance and based on substantial evidence. In addition, the act requires those requirements and conditions to be reasonable and to be the exact practical measure. So basically, if I agree to adhere to all the federal, state, local ordinances, which I do, there's really no reason why this board or the town board or the county board can deny my conditional use. I also have something that I obtained here through open records request, and I got this just a few days ago. And Attorney Mills, which is the town attorney, wrote a letter to Michael Cotter. And I'm going to read you that letter here. It's not very long. It's good afternoon, happy 2025. This is Jim Mills to Michael Cotter. I'm writing you as there's been some questions raised about the attached rezone ordinance signed by the county board and clerk on January 14th. The county ordinance mentions the GIS system, but there is no language at all that speaks to split zoning or the fact that C2 zoning classification near the water is not being rezoned to C2. Is it possible to add that distinction in an amended ordinance? There is some confusion as I'm trying to clear up. So any guidance on the sufficiency of the executed ordinance amendment is appreciated. If the C4 portion near the water has not been rezoned, I am confused as to how an applicant can run a marina with no water or boats in the portion of C2 of the rezone, besides the parking, lighting, accessory structures, etc. Anything clarification would be helpful. The matter comes before the Town Planning Commission on February 5th, 2025, so your prompt attention is appreciated. Second paragraph here. Second, the town code includes an ordinance that governs marina permits. To obtain a marina permit from the town board, the applicant must file a permit with the town clerk and the Lake Beulah Management District. As you know, the town does not have its own zoning. Further, case law is clear that the legislative has given shoreland zoning authority to counties, not towns. See Hermans versus City of Walworth. 286 Wisconsin 2nd 449 7039 W2D 720. As cited in OAG-01-19. I know that county defines a marina in its zoning code and also listed as a conditional use allowed in the C2, but I do not see any other regulations of marina. If that is correct statement, do you believe that the county still has jurisdiction to hear this marine applicant, or is it something relegated to the town? That same town ordinance goes on to state that if it shall not supersede or affect any other more restrictive provision of the municipal code of the town of East Troy or any other entity with jurisdiction, in parentheses, emphasis added, that would be Walworth County. Some could try to argue that a marina permit and rezone are separate issues. I personally am having a hard time making a distinction between the two. To me, the comparison that one would try to make is like describing the word marina as a noun thing, and then also as a verb, operation or use of the property. Because a marina is allowed as a conditional use in the county zoning code, I do not know if the town ordinance regulation that simply requires a permit to be filed with it is sufficient to take the decision-making away from Walworth County. Further, in light of last year's 2023 Wisconsin Acts 264, because the town of East Troy has adopted county zoning and Walworth County comprehensive plan and amended that followed, do you believe that the town ordinance regarding marina permits has been superseded? 2023 Act 264 and Attorney General opinion I cited are attached with the relevant portions of the Town of East Troy Municipal Code. Give me a call if you wish to discuss the same or believe that a meeting is preferably. I look forward to your opinion. So then Michael Cotter writes back to Attorney Mills. And this was on February 3rd, 2025 at 1:43 p.m. And he goes, and then everything that I read that's Cotter's is going to be in red, and everything that I read in black is going to be Mills's. So Jim, I will attempt to answer your questions paragraph by paragraph. I am also copying Darren, Kate, and Nick on this response. If anyone else has something to add, please chime in. I am writing to you as there's been some questions raised, this is Mills, about the attached rezone ordinance signed by the county board chair and the clerk on January 14th. The county ordinance mentions the GIS system, but there is no language at all that speaks to the split zoning or the fact that the C4 zoning classification near the water is not being rezoned to C2. Is it possible to add that distinction in an amended ordinance? Okay, now this is in red. This is Cotter speaking. The engineer for the application provided a digital file of the area to be rezoned. Often a surveyor engineer provides a legal description. In the case, we received a digital file that we are able to upload into our GIS system. If you look at our GIS system for this parcel, you will see where the zoning line runs and can now understand why you would question this, but we've properly mapped the rezone request. And for note, I did check it today, and the property does have the wetland delineation line right along the edge of the shore. All right, this is in black, this is Mills. There is some confusion as I'm trying to clear up, so any guidance on the sufficiency of the executed ordinance amendment is appreciated. If the C4 portion near the water has not been rezoned, I am confused as how an applicant can run a marina with no water or boats in the C2 portion of the rezone, besides the parking, lighting, and accessory structures, etc. And if your clarification would be helpful, the matter comes before the Town Planning Commission on February 5th, 2025, so your prompt attention is appreciated. Now this is in red, this is Cotter answering him. As you indicated, the applicant's proposed parking and storage related to the marinas are located in the C2 area. This marina discussion is all proposed because the applicant has not appeared before the county zoning agency to discuss his marina application. The C4 zoning district allows for hiking, fishing, trapping, hunting, swimming, and boating as a permitted use. So what he says in English is if you want to walk across the C4 to get to the piers, you can get to it
Why don't you just read what he actually says?
Sure, no problem. Okay. In other words, the landward use of the marina is proposed in the C2 zoning area. Crossing the C4 strip of land to access a pier would be a use allowed under C4. We've litigated and lost a similar argument related to the Lauderdale Lakes aqua skiers. The aqua skiers had a walkway and a viewing area for their ski show located in C4 district. And I believe they even had bleachers and a trailer located in the C4 area, but I don't remember all the specs. Okay, now this is in black, this is Attorney Mills. Second, the town code includes an ordinance that governs marina permits. To obtain a marina permit from the town board, the applicant must file a permit with the town clerk and the Lake Beulah Management District. As you know, the town does not have its own zoning. Further case law is clear that the legislator has given shoreland zoning authority to counties, not towns. See Herman versus Walworth, 286 Wisconsin 2D 499 7039 W2D 720. As cited in OAG-01-019, I know that the county defines a marina in its zoning code and also lists it as a conditional use allowed in the C2, but I do not see any other regulations of marinas. Now it's in red, this is Cotter speaking. We do have an additional marina permit. We do not have an additional marina permit or anything like that. The marina would be regulated under the terms of the conditional use. Now this is in black, this is Mills. If that is correct statement, do you believe that the county still has jurisdiction to hear this marina application, or is it something relegated to the town? This is in red now, this is Cotter. Yes, the county holds jurisdiction for a conditional use permit related to a marina, and we have not relegated this authority to the town. Now, this is Blackett's Mills. That same town ordinance goes on to state that it shall not supersede or affect any other more restrictive provision of the municipal code of the town of East Troy or any other entity with jurisdiction, emphasis added, that would be Walworth County. Some could try to argue that a marina permit and zoning are separate issues. I personally am having a hard time making a distinction between the two. To me, the comparison is that one could try to make is like describing the word marina as a noun thing and also as a verb, operation or use of the property. Because a marina is allowed as a conditional use in the county zoning book, I do not know if the town ordinance regulation that simply requires a permit to be filed with it is sufficient to take the decision-making away from Walworth County. Now, this is in red, this is Cotter speaking. I do not agree that the decision-making was taken away from Walworth County. And then this is Mills in black. Further, in light of last year's 2023 Wisconsin's Act 264, because the town of East Troy has adopted county zoning and Walworth County comprehensive plan and amended that followed, do you believe that the town ordinance regarding marina permits has been superseded? This is red, this is Cotter. I cannot speak to the town's ordinance. I know this marina proposal requires a conditional use permit from Walworth County. If the town has the authority to require an additional permit, that is outside of my review. In some cases, the county can issue a zoning permit and the township may have more restrictive requirements. When we issue the zoning permit, the applicant needs to meet the town requirements for a building permit. Maybe the town requires a larger square footage or has a more restrictive height requirement. I cannot think of a specific example in the shoreland area. If you have any further questions, please let me know. Then, yeah, and that's it. That's the end of Cotter's letter. So basically, what it addresses is here is the town ordinance right here. And it says that you're required to come to the town board and you're required to go to the management district for a marina permit if you apply for it. And basically what Cotter explained there is that the jurisdiction wasn't relegated to the town to supersede the county. So the county is the final decision maker in the conditional use. So I don't think it would be appropriate if this board listened to a bunch of things that are said by the people that want to speak for public comments, because Act 67 doesn't care about what people say. All they care about is you're complying with this book, and everything you're doing is not contrary to what's in this book. That's all I got for now.
Any questions for the applicant while we've got him?
Yeah, I have a question. So, on your plat survey, and it looks like the wetland and the C4 zoning, which is that wetland area, bounds the Lake Beulah entirely. Do you have is there any portion of the parcel that's currently zoned C2 that abuts the lake?
I'm going to check for you because I took a screenshot of it today off the GIS view. I believe there's not, but I don't want to speak yet. Nope. According to this right here, the little yellow line, it means the wetland delineation line is north of the ordinary higher water mark. There's a small gap, 5, 6, 7 feet between the edge of the water and where the wetland delineation line is. So the answer to your question is there's no portion of the C2 property that touches the water.
Okay, and to clarify, so you have a parcel that's split zone C2 and C4, and you're applying for a conditional use for a marina, which is allowed under C2 zoning.
Mm-hmm.
Is it allowed under C4 zoning?
We're not doing it under C4. The use that we're doing is we're asking to boat off the pier there. And a permitted use, if you look in your packet, I believe I included in your packet, a permitted use in C4 is boating and swimming. So if you want to boat or swim in C4, it's a legal activity. So we're not doing anything that's illegal in C4. Now, if we were doing commercial stuff down in the wetland area, that would be illegal, but we're not doing anything commercially down in that wetland area.
So Ben, I think I can kind of clarify. He can do all his marina operation on the C2 and he can cross the C4 to get to his pier, according to Michael Cotter, the attorney for the county.
And then I didn't see your application is pretty minimal. Have you provided us with any information with regard to your hours of operation?
The hours of operation have been
or-
explained in great detail at the county. And the hours of operation is the same as the marina across the street. They're 24 hours a day. We don't do anything in the middle of the night, but there are on occasion where somebody will go out in the middle of the night to go fishing for walleyes or whatever. But generally, we don't have a lot of activity in the middle of the night. But currently, across the street, there's 24-hour use for the marina there.
And days of year?
Every day. Well, obviously in the wintertime, they're not going to be fishing in the middle on the ice, but yeah.
And I'm sorry, I didn't see any detail, but did you mention, you read off that letter? I didn't see that letter in the packet, so if you could.
No, I just got that letter a couple days ago.
Okay, so if we could get a copy
I
of that.
think
I could review.
Joel has a copy of it.
I thought it was emailed to everybody, or was it just me? Everyone? Okay,
I
it's
might
in
have
your email.
overlooked it, but, so were you planning on constructing any lighting or parking, or was that just?
We don't plan on changing anything on the property. We're not erecting anything. We're not doing any land disturbing. All we're doing is basically shuffling paper so that we can park up on top there and we can access the piers that are currently in the water. We're not building or constructing or erecting anything.
I guess, Chairman, I have a number of other questions. There's a lot of detail that wasn't provided. Typically, we're provided with like number of parking spots that are going to be used, that sort of thing. I'm just not seeing.
That was provided. It's in the packet. It's 8 commercial parking spots. And then it's 8 commercial pier spots with 2 personal pier spots.
Normally, it's outlined. Typically, what we'll have.
I believe I gave you a
I'll-
copy of a survey that had all the parking and everything on it. You must be looking at an odd one there. Because I do believe let me see if I have that in my packet. That was provided, then.
Okay, I think I have it here.
Yep, that's it.
Okay. I think that's all I have for now.
Anybody else?
Yeah.
Yeah, please.
Do you intend to provide the ability to launch boats from the property?
Not for the public, no. For my own use, for my own repairs. A lot of times I'll have a boat that goes out, it comes back, say with a smoked impeller and it's not pumping, and that boat's scheduled to go out a day or 2 later. I may need to pull my own boat out and put it on the shore, put a new impeller in it, but I'm not going to be launching boats to the public, no.
How would you do that if there isn't a launch?
I would take a forklift that I own and I'd pick it up and set it right on the water. So nothing would be going into the lake, it would just be picked up and pulled out.
And how many piers do you envision in this marina?
The same amount of piers we have now is 2.
2.
And for the record, when I turned in my original application back in 2008, I do have wharfs along the edge of the pier, the edge of the shores. I've never installed the wharfs yet, but they are on my original permit. So I may put some wharfs in along the shore, but that's already been permitted for on my original application from 2008.
Wharfs along the shore?
I'm not sure. Where you're
All right, what a wharf is a landing that's parallel to the shore versus a pier, which is perpendicular to the shore going out, yeah.
And then you state that there's no, in your application, you state there's no change in the impervious calculation, which would imply you're not intending to do any paving.
We're not gonna do any asphalting, no concrete work, no.
Buildings.
No buildings, no,
roofs.
no.
And your conditional use application was revised in October to include the year-round use of an airboat watercraft?
Yeah. My eventually goal is to get a few ice shanties that I can take out and rent for people off that property
In the
there.
wintertime.
Yeah, and that's where the airboat would come in, because if you have questionable ice or whatever, you want to be able to get them out there.
And then the application includes an excerpt from the zoning code with the definition of B3 and, which is the waterfront business district, and with the principal use highlighted of boat rental. Why is that included in the application?
I think when I was going through to try to find the definition of marina and what it entailed and the number of slips, that's all I could find in the zoning code. Walworth County is not super clear when it comes to defining of a marina. They have one short little paragraph as they describe it. And I was just trying to put that in there to give you guys an idea when you look at it, what we're talking about.
Yeah, but the B3, we're not talking about.
No,
B3.
this property is not B3. The property across the street to the west is B3, but this one has no B3 associated with it.
Okay. Any other questions for the applicant?
Yeah, I have a couple of questions. Is this a split zone?
I think you could call it a split zone because originally when the rezone was done, the whole property before was in C4. Okay, now after the wetland delineation survey work was turned in and went through the whole process of here, town board and county, they decided that the portion from the wetland delineation line northward was going to get a new zoning. So there is split zoning. The very edge of the shore is C4, and then the portion from the wetland delineation line going north is now C2.
I have seen that when you have a split zone, the new zone, which would be the C2, right? That's the new part.
That's the part that was changed, and that's
Yeah,
what's called the
that
predominant
is
zoning.
pertinent to C4. Otherwise, it has to follow the same regulations as C4 does, which does not allow.
No, the C4 portion is the minority on my property. It's just a few feet along the edge. The majority of my property is the C2.
Yeah, but that doesn't refer to the majority or minority. It refers to what was the original zoning before it was split.
Okay, what happened was when the wetland delineation was done twice, the delineation line was in the same spot, both delineations. Both times it was delineated, it was in the same spot. So what that's meant in English is everything from the wetland delineation line going north is mismarked, it's miszoned. So it was a mapping error done back in the early 70s.
Yeah, I haven't seen any evidence about a
Through my conversations with
Well,
the
we're not
county-
gonna rehash the rezone. It's zone C2 right now. It is.
But it is
Not all of it. It is split zone.
pertinent to the C4.
What do you mean by pertinent?
Yeah.
It is subservient to C4. It
No.
has to follow the same.
Can you point that out in the book right here where it says that? I can't, because I've looked through this book hundreds of times and I couldn't
Sure,
find it in there.
give me a little time to go through and find it again.
All right.
Why don't we hold off on that, Rich, and maybe you and I can discuss and I could get a
Sure.
clarification maybe from
One
Attorney
more
Mills.
question.
By all means.
Did we get a new delineation from the DNR?
No, it wasn't required because you got a letter from Allison Meeks at the DNR, and she said as long as we're not doing any land disturbing, it's not
Well,
necessary.
she said as long as there are any new future projects.
And there's not going to be any new future projects in the
Well, this is a
C4.
new future project because you're getting conditional use. Right now,
Okay, let me ask you, what are we building? I just said we're not going to build anything. Are we doing any land disturbing? I said, we're not going to do any land disturbing. So we're not doing anything that would require it turning into a new project.
I think what you're saying is there's already a marina there.
Everything is there. We don't have to change a thing.
Yeah. And my point is that arena is not supposed to be there.
Is it a marina? Technically, it's not a marina because it doesn't have the right zoning, doesn't have the right conditional use tied to it. That's what we're trying to correct. We're trying to correct the mapping error that happened 50 years ago.
Okay, well, that's not how I see it, but that's
Okay.
okay. I understand what you're saying.
I think the main thing to take away from our meeting tonight is I do plan to adhere to all the rules in that zoning book. I do plan to adhere to all the federal, state, and local laws. So I'm not going outside or contrary to what is required of me by that book. So there's really no reason why I should not be granted a conditional use permit
Well,
as long as I follow all the
unless
rules.
we can provide a reason to deny that's based on evidence.
Yeah, based on evidence that I'm contrary to that book,
Well, we
correct?
don't have to argue whether we're gonna decide in favor of
Okay.
you or not. So, do you have anything else, Rich?
No, that's all.
All right, thank you. John, do you have something else?
Yeah, so you want approval to put in parking, 8 parking spots in the new C2.
Correct.
And in your mind, is that allowed as does it list that's a conditional use of
As
C2?
long as I was able to get Kate Hastings' signature on my application, which meant that we went over in great detail. I had 5 or 6 long meetings with her, and she said, what you're doing there meets what's in the code book. So that's why she gave me her initial on my original application.
Well, they haven't approved a conditional.
No,
use, so
absolutely
that's
not.
just approval for.
It was approval for everything I was coming forward at the time meets and is not going contrary to what's in the book.
But what I'm saying is, in order for the conditional use to be approved, parking would have to be an allowable conditional use of C2.
Correct, which it is.
I don't see that listed in the.
Sure.
Well, she wouldn't have given me her signature on my application because we went over this whole thing, the parking in great detail. You need so many feet radius in the back. We went over all that in great detail and she wouldn't sign off on this because she's a senior planner at Walworth County. She wouldn't sign off on my application if I was trying to do something outside the box right in the beginning.
Any other questions for the applicant? All right, thanks.
Thank you.
Quick discussion amongst commissioners. I guess I don't have, I don't, we're not gonna make a decision on this tonight. Obviously, we have some homework to do. I guess all I'm gonna say, conditional use is just that. If he meets all those criteria, we can put whatever conditions, reasonable conditions on it. So I guess that's what I'm that's my take, if you will. So, any other discussion before I open up to the audience? All right, would anybody in the audience like to speak in favor of the proposal? Would anybody like to speak against the proposal? If, again, I know you know the drill, but name and address, please.
My name is Robert Miller, N9124 Humphrey Lane. I was town chairman when, and I'm here to speak to the parking area.
Sure.
At that time, John created a cutout into the hill along Stringer's Bridge Road. And he did so without a permit. And I specifically met with him at night. We're going to look at that. We had, I asked him to see the permit at that time. He didn't have it with him. I told him it was supposed to be posted on the site before work was done. My site viewing took place early in the morning after midnight. He was doing the work with lights in a tractor at night, the dumpster and dump trucks. The next day I called the county to find out about the permit. And I talked to Debbie Gruby, who was the zoning officer for that at that time. And she specifically told me that there was no permit and that she had a discussion with John and he asked if a permit was necessary for excavation. And she said, she told him, I think if it was less than 10 yards or 8 yards, he would know. It wasn't necessary. If you've been to the site, by my estimate, probably 1,000 yards were moved and hauled out of there. Because of that situation, we had meetings with Debbie Gruby, Chief Jim Surges, who was chief of police at the time, and the county sheriff. And they came out and looked at the site and had grave concerns about where the parking would be because of the way the road curved, and it's kind of a blind entry into it. John pleaded that it was harmful for him to make restoration, because that was the first suggestion. And that his intention was, there was an old hunter's cottage, I'll call it, on the site, and he was gonna take that down and build a house.
Could you just make sure that you just put your comments towards us? We don't want it to get personal,
Okay.
please.
He was gonna build a house in the footprint of the old cottage, which never happened, and the cottage is gone now. As a result, and it was a mistake on my part, we agreed to let him keep it. However, per the permit, and that's why I suggest that the planning commission in the town look at the permit, because there was a clause in there that said he could park one, I think the maximum was 2 personal vehicles, not for
So
business.
you're saying he got a permit retroactively?
He had a retroactive permit. The work was complete before he had his permit. Second, with those disclaimers in it, he signed it back at that time. He didn't have to make restoration, but was limited to 2 personal vehicles. Over the years, he didn't do a good job of that. He parked dump trucks in there. He parked school buses in there. He was, I believe, cited by the town several times for parked cars there. He was using it as a parking area, and that was the concern. You got to find the permit. I don't have access to it. I'm sure the county's got a copy, and I think possibly the town does.
Okay.
But that being said, he wants to follow the rules and the orders. If he agreed to make it a personal vehicle parking area at that time, I don't see where he can come back in now and say, I want to do business parking.
Okay.
That's all I've got.
Thank you. Anybody else? By all means.
Hi, my name is Beth Lamb. I live at W1544 South Shore Drive. I am speaking tonight for the Protect Lake Beulah organization regarding Mr. Stosa's request for the conditional use permit for a marina on his property. I personally attended the December county meeting where his rezoning took place from C4 to C2, and that part was approved. The drone pictures that were presented at that meeting made the situation much more clear to me. The county approved a rezone of part of his property for a parking lot, I think. But the foot or two of property along the lake remains C4. Today, he's asking for a conditional use permit to create a marina at the lakefront. Since the actual lakefront remains C4, we do not see how this would be possible or appropriate, and believe it actually is contrary to the Wisconsin law, which mandates special protections to these critical habitats. Walking to boats or piers or driving boats to the shoreline would entail walking through and or disturbing what remains sensitive area of the C4 zoning. Additionally, we would ask that you require a new certified survey that defines the wetland delineation of this area, since the area has been disturbed since it was last, a certified survey was last done. We would like to point out that there has never been a marina in a C4 delineated area in the state of Wisconsin. We would ask that you do not approve this conditional use request. In addition, I would like to read a part of a letter from Jennifer Thorsch, who is a current board member of the Protect Lake Beulah organization. Jennifer's husband's grandparents bought property and built a house on Lake Beulah in 1936. Jennifer and her husband are owners of this property on Humphrey Lane today. Jennifer holds a PhD in plant sciences. She's the founding director of something called the Cheadle Center for Biodiversity and Ecological Restoration at the University of California, Santa Barbara. In her capacity as director of that group, she was responsible for the protection, management, and restoration of over 350 acres of sensitive marine habitats on the university campus. The area being proposed for this conditional use as a marina is of critical importance to the environmental health and preservation of this sensitive habitat on Lake Beulah. Quoting from the Wisconsin DNR website, sensitive areas of lakes are designated as critical habitat areas in Wisconsin. These areas comprise of aquatic vegetation identified by the Wisconsin DNR as offering critical or unique fish and wildlife habitat, including seasonal or life stage requirements, or offering water quality or erosion control benefits to the body of water. Wisconsin law mandates special protections for these critical habitats. It is important to note that areas surrounding the critical habitat may have impacts on these areas, including development, runoff, and improper use. Therefore, it is critical to prevent areas surrounding the critical habitat from causing irreparable damage to these sensitive areas. The proposed site for conditional use is also important because the origin of the water flow to this site is Pickerel Creek, which is a diverse, high-quality sedge meadow and fen. The sedge meadow and fen grades into a high-quality tamarack swamp and then into an emergent marsh featuring cattails and bulrushes. The site is included in the Pickerel Lake fen in the sewer pack and Walworth County Natural Areas plans and is designated as a natural area of statewide importance. From an environmental standpoint, Jennifer recommends no development in the C4 area. That includes boats, mooring, moving through this area, disrupting the vegetation and the lake bottom. Again, we would ask that you do not approve this conditional use request.
So the only one thing I'll just respond is according to Michael Cotter, the attorney for Walworth County. He says C4 zoning districts allows for hiking, fishing, trapping, hunting, swimming, boating as permitted use. C4 also allows boat access as a conditional use. Obviously, piers and boats are allowed in the water. In other words, landward use of marina proposed on C4 area, crossing the C4 strip of land access would be used as it would be allowed under C4 to basically cross perpendicular or whatever across the C4 from the C2. Again, I'm not defending anyone. This is just what I've
But
found out.
The additional complexity is the fact that this is a special, what's the term?
Environmentally sensitive
Area of
area.
special natural resource interest, ASNRI. That's the additional twist to this particular
Sure.
parcel. Correct.
Got it. Thank you.
I just mentioned, Jeff Steinick, W 1969 Itzler Road. I just have two additions. You did mention that Cotter did say you can walk across. What he's not saying though is C4 is not for business or for marinas, so he should have clarified that because it is C4 and he's asking for a marina, that is not allowed to use C2 to cross onto C4. That is as if you have a wall saying you don't cross for business purposes.
Not according to Michael Cotter.
Well, I would challenge that.
Understood.
clarification.
Okay, yeah,
Otherwise, why do we even have C4 and C2?
I totally agree with you.
It's a,
Yeah.
that needs to be clarified big time. Because I don't see how you could cross over and have a business. And then on top of it, what he's really saying to us, he actually has the cart before the horse here. He should have actually come to this meeting with a permit in hand. And what he's doing is he's asking for business moorings when he doesn't technically even have a business right now. So it doesn't make sense to me. And the other thing that I would point out is what he's really telling us is what we're talking about crossing over. What he's really saying is if he asks for 8 business, basically he's saying that gives me the right to run a marina through C4. It's wrong. And the other thing is the delineation should be required because if you take a ride there today in winter, I have never seen a shoreline. I'll start with the peninsula piece of the property against the road, sticks out, comes to a perfect square. What shoreline do you see that comes to a square and then does a perfect cut across? And then guess what? As soon as the lot line ends, when his neighbor shows up, it's wetland, it's in the water. So for him to say he's not disturbing, that is a crack, and you should demand a delineation. Because he is basically taking earth off the shoreline, moving him closer to C2, which is illegal.
Thank you. By all means.
Thanks. My name is Troy Giles. Address is N16W23250 Stone Ridge Drive in Waukesha. I'm an attorney and I work with the Lake Beulah Management District. Just a couple things. I sent a letter to the Planning Commission and I wanted to know if that will be accepted into the record without me having to read the entire thing this evening.
Absolutely.
Okay, all right, thank you. Just a couple notes. I know we've talked a lot about the C4 zoning and whether or not, and the operation of a marina in it. I just want to make one additional comment regarding why I also think it's inappropriate and a CUP would not apply in this instance because the shoreland is entirely C4 zoning. I had a number of people in our office research the matter of split zoning and figure out what that really means in the state of Wisconsin. It's a highly undesirable zoning classification is the bottom line. It's akin to spot zoning and it leads to a number of different problems. But the overwhelming authority that I've placed in that letter states guidance from Wisconsin municipalities state that split lot zoning requires that each section of the split zoned lot must meet the requirements of the district in which it lies. In other words, you've got a marina that's being proposed here that is adjacent to and appurtenant to land that is zoned C4. That is inconsistent. It does not adjoin, it is not adjacent to C2. But what the applicant has managed to do here is to put a parking lot and other surfaces based upon a 13-year-old survey in an area that is zoned C2. Look at the definitions of both C2 and C4 zoning. Both of those are dedicated to the preservation of environmental characteristics, of the betterment of the environment, of the protection of natural resources. Look at the opening part of it, C4 zoning. It's summarized in my letter. It's right there for you. It's taken verbatim from the zoning code. They are to protect natural resources. This doesn't do any of that. Okay, that's point number one I wanted to make. Second thing, how are we possibly here without the Wisconsin Department of Natural Resources giving their opinion about this? The number of slips that are being requested under this proposal exceed what would be permissible under Chapter 30 of the Wisconsin state statutes. In order to get 10 slips on a property that is roughly 119 feet wide at using a meander line, which is the proper method of calculation, not using a wheel and running around and measuring the entire distance. There's 10 slips on a property that is being 119 feet wide. That will require him to go through the individual permitting process that is set forth in Chapter 30. It's all set forth in this letter. Okay? Grandfathering. Grandfathering, you just heard the applicant say that he did not and is not operating a marina, right? Or at least he challenged one of you here as to whether that's happening. Grandfathering, whether or not a pier system is grandfathered, is whether or not you can prove to the DNR beyond a shadow of a doubt, the burden is on the applicant to show that the number of slips that exceed what the state of Wisconsin requires were in effect as of April 17th, 2012. Okay? You have to show that to the DNR. They have to look at aerial photography. They take records. They do everything they can to establish that. And it's a fairly high bar. And if I don't know if anybody here has read the case involving this same property that was decided by the Wisconsin Appellate Court, but the court concluded as West Rod did not meet its burden to show that Fred's Tap had an active and actual boat slip rental marina operation prior to the adoption of the county shoreline zoning ordinance in 1971, or that it actively continued such an operation as more than an occasional and incidental use, we affirm the decision of the circuit court.
Fred's Tap's a separate property.
But look at the case. The case law defines the property that they were using as being both Fred's Tap and the one across the street. They're combining the two in this decision.
Okay.
Okay.
I didn't read the decision.
It's
I'm not
there.
arguing with you.
Do you have a copy of the decision?
I don't.
So, okay, going back to a few other things. We've talked about C4 and C2 zoning. This is in an area of natural resources special interest. There are higher standards that the DNR will look at before they entertain allowing more slips than what is allowed under state law. And I think everybody else has probably covered most of the stuff, but again, we are disappointed in the way it's been zoned, the change that's been made. It leads to confusion, but the Lake District is adamantly opposed to the operation of a marina at this location.
Go ahead. If you wouldn't mind.
Mr. Giles,
Yes.
what is your experience that allows you to take the positions you're taking? You're an attorney?
I'm an attorney. I write the environmental section of the Wisconsin State Bar book that is published throughout the state every single year. I work for a law firm that has 220 lawyers. I specialize in both real estate and wetland laws. I've worked on these types of marinas throughout the state of Wisconsin, from the northern part of the state to the southern part of the state. I've got active matters going right now in Dane County, Jefferson County, Wapaka, Waushara, throughout the state. So I'm pretty familiar with these issues.
Okay, so you make the point in your letter that you don't believe that a marina serves the purpose of the intention of C2.
Correct.
Okay. And the applicant has committed to us that he's going to meet the purpose and intent of C2. So that's the big discrepancy we have here.
Understood.
And you state in your letter that a C2 conditional use does not include a parking lot.
Correct.
It includes a marina, but it doesn't include a parking lot.
That's right. That's right.
Okay. And I believe you also point out that, if I understood you, and please clarify, that a marina is not compatible since the property is in a area of special national resource interest. A marina would be incongruous with that.
I agree with that. Look, we're talking about, no matter how anybody tries to sugarcoat it, this is a commercial operation. This isn't necessarily providing access for people on a daily basis. This is to rent boat slips for the purpose of making money. It's a commercial operation, okay? You've got areas, my understanding in talking with some of the folks from the DNR and some other water law attorneys, that Lake Beulah's got problems with traffic. There are a lot of people on this lake that use it, and it suffers a lot from traffic. You've got sensitive areas that are being affected by increased traffic. The operation of a commercial marina in an area of sensitive resources is a dangerous combination. The one other thing I did forget to mention too is that maybe my memory is wrong, but when I was here in June listening here in the audience, I thought the Planning Commission had asked for and the applicant had agreed to provide an updated wetland delineation. And the importance of that is that we now see it is the line that determines where the zoning begins and ends between C4 and C2. If there's been any sort of land manipulation filling, grading, things done potentially without the consent of the DNR or without having them be permitted, a wetland delineation needs to pick that up and that needs to be reflected. That's all I have.
Anything else, John? Okay, thank you.
Thanks.
Anybody else in the audience like to speak? Please.
Bernard Baum, and 8634 Stringers Bridge Road. You said you didn't have a copy of this.
Thank you.
I'll give you another one later. On page 3 of it, this was an appeal. I was at the courthouse 2 weeks ago. They could not find the case number original. In fact, their words were, "How did you get that?" Right on the bottom, it says, "This opinion will not be published." And you read the last page. Anyhow, page 3, Waller County issued a citation for operating a marina, C4 zone district, Waller County zoning ordinance. 3-day trial, circuit court concluded West Rod failed to show predominance, how you pronounce it, of the evidence that the marina operation was a legal, non-conforming use and imposed a $663 forfeiture. West Rod appeals. This is the appeal. The last page is what the attorney read to you. He's been using that property as a marina since this county has done absolutely nothing. Why? I mean, I've called them on other things involved with this. That's your second copy. I have another one. Anyhow, that's my opinion. He's been doing it for 10 years. Who cares? County don't care. Why should he have to get any permits to do it? County doesn't care. He's doing it now. Why should he have to go to you, go to the town, go to county zoning? He's been doing it for 10 years and was fined by the judge. That's a circuit court order. That's all I got to say right now.
Thank you. Anybody else in the audience like to speak?
I'd like to, if I have time. My name is Scott, I'm about 2415 Route 11. I apologize. It's been a lot of work and I just live next to it. Maybe I can pass these to you. This is on the other side. It's not his property. It's considered wetlands. He doesn't own it. This is how he makes his new frontage on where he wants to make his new boat marina. He can cut it out like a dime. He's an expert running that equipment. And you see that's not his property. And I think you can see those two people that are in there are those two people. You're laughing.
We're not gonna have these discussions back and forth. He's gonna talk to the
I'm
board
trying to,
and
but
you're gonna let him talk.
Please.
That's it. Proceed.
And he was in my yard after the first
If you
meeting.
could just talk
I'm
to us,
sorry.
please.
I have to
I'd
spread out.
appreciate that.
All right. He's been down there a long time. I also came by when he was digging out the hill. I don't know what year that was. I wish somebody would know what year it was. Does any have any idea when he was digging out here without a permit? I believe it was right around 2011 when this was happening. So what he was doing in Milwaukee, he was doing exactly out here. You've all read this, right?
Yeah.
40 truckloads at night.
Yep.
Some of the truckloads probably went back to some of the work in Milwaukee. You got an honest guy. He's not an honest guy. He's parking boats down there right now. We've got pictures of him doing it, lauding. He's got a property up on top with all the equipment. He's running down the road with boats on his equipment. He clears it up nicely. I just don't know what's taking so long. None of the neighborhood likes him. He brings people in here, the big volume and all that, and you know, we're all friends. We went to the meeting with the boat wave thing, the problem in the area. You know, the talking out at the pavilion. I was out here.
Yeah.
There was a lot of people. I don't know if other people were there.
Okay.
It's about the wave running. John was there talking about his safety again, which is also bull. There was about over 100 people there, and I got there a little later, and there was only one table with one person on it, and that was Mr. Stouts. And all he talked about was his permit and his safety.
Okay.
Okay, I'm just telling you, I mean, I've got a bunch of stuff here. in
I just, I
Milwaukee.
don't want to sit here and let it get personal and
Me
let it be
neither,
a
and that's,
personal attacks.
yeah, I don't
So if you
wanna-
have some facts you want to bring up, we'd love to hear it.
Personal, what kind of facts do you want? Those
I
are facts.
don't-
He's against the.
We have a lot of facts, so if
Okay, I
you want
got
to say
that,
something, by all means.
On that other side over there, years ago, this gentleman in Freddy's had a gun, shot across at the gun camp. All the neighbors knew that. They went over there and he threatened one of the neighbors. That neighbor's a businessman and owns a property down the avenue and was the second house in.
But I don't know that has any relevance on a conditional use of what we're talking about tonight. And I don't mean to cut you off.
No, that's a problem. If you can come in there late at night and make your yard bigger by removing to the north. And at night, you can come down there and on the other side where the pier is there with the DNR, did make him take some stuff out. I think we all know that. Is that correct?
Mhm.
So he was made on the other side with the pier by the DNR to take stuff out. He's on the fourth side of that bridge, on the bridge, stopping the traffic with those pictures, working on an area he doesn't own. And we're trying to talk about trust and honesty for the community with this business, as he was on disability in Milwaukee and doing the two jobs out here in Milwaukee. If he's gonna also go to the waterfront and use the machinery like a scissors, which I watched him do, and the barge, he can make that perfect line when you have the drone going from the bridge to the east, just a little bit longer. That land is not 240 some feet. And I think you guys know that. And it's the same thing he did in Milwaukee. It was exactly 200 feet in Milwaukee. And it's almost like he's got a carbon copy of what he did 20 years ago. Exactly the carbon copy. One of the reasons you have that child crossing sign up there that he was the one to propose 20 years ago when he came in here, that was his idea. The first thing he did was dig out the hill. He talked about it at one of the last meetings about Booth Lake, bringing the bubbles over there. Put it over there at the dock side where they need it when you come down. That's another suggestion. The only reason he wants that bum straps down there, down Stringer's Bridge, is so he can run the whole gamut down there from where he lives, because he doesn't live at Freddy's, which he claims. During the summertime, I'm sorry, my wife and I came down there with some guests a couple times. His patrons are urinating in the open. There is no bathroom facilities. This is on the Freddy's side. We came to the bridge heading west where we live. My wife's looking at this guy's wife and he's doing his thing. I go to Canada, I understand the situation. Does he have a working septic at Freddy's? I don't believe it. You can do it that card that every 3 months. There's a sort of a little portable bathroom. I don't think any customer I've seen down there of his customers is used that. I don't want to see that anymore.
Okay,
That's it.
thank you.
Linda Zerner, and 8784 Stringers Bridge Road, East Troy, obviously. I'm not an attorney, but with using our middle school as an example, us taxpayers pay for county and town decisions. East Troy, Stringers Bridge Road is very dangerous. There's already so much activity going down there by Fred's. I've had close calls, numerous, and I feel like I'm living Groundhog's Day because I've spoken to you all about this before with little boys that were gonna shoot out going from the lakeside over to the bar side. An older man, yes, they want to enjoy life, but he's standing in the middle of the road on the medium strip and cars are whipping down the hill. Something is going to happen. We as taxpayers will pay the lawsuits for the injuries or death, just like our middle school in East Troy. Our town and our county make the decisions. We as taxpayers pay the consequences for that. So I would be against it for that reason. I was former guardian of Fred's Tap prior to John Stas purchasing it. I recall Fred trying to do something more on the lakeside. And what they suggested was to build a bridge over the road so people could cross over at his expense, not the town's expense. Just to keep people safe. Now, would you get a semi under that bridge, perhaps? I mean, how far do you go? But safety is the biggest issue in my mind because we will have our taxes go up when someone is killed or injured. People at the marina don't pay attention to a road. They think they're at a marina. The road is the marina. They're not paying attention to the traffic. I've had many, many close calls, just myself, so. Thank you.
Thanks. Anybody else wish to speak, please?
Carrie Franzine, W1530 South Shore Drive. I just want to highlight one of the things that John Stas said that has not been discussed here for maybe something that should be looked into. First of all, he said he's not going to make any changes. He's not going to put any structures, any concrete, any of that there. Then he says he has a permit to add wharf. I'm wondering if we need to be looking into that further. Is that grandfathered? Is that wharf going to be on the C4 part of the land? If it is, I'm not sure how that permit would have been in place in, what was the year? 2014, when it would be grandfathered. So I don't know. I just think it's something maybe that should again be looked into.
Thank you. Anybody else like to speak? All right, thank you. John, if you feel like you need to have a rebuttal, go ahead.
All right, well, the first thing I want to address is the former town chairman, Bob Mueller, who's no longer here, and I'm addressing this to the board. He got up and said he's doing all this work in the middle of the night and he's got all these restrictions on this permit. Well, Bob, why don't you bring your stuff in and show me your documentation? Because otherwise it's just hearsay. So it's, you know, it's a guy pontificating on his soapbox up here, which means nothing. Michael Cotter addressed the issue of walking across the C4 to get to the piers. I don't plan on parking any cars in the C4 area. I don't plan on selling hot dogs in the C4 area. I'm not going to be doing anything commercially in the C4 area. And the C4 area is a very thin strip along the edge of the shore. Most of the lots around the lake have a little C4 along the edge there. It's just kind of the nature of the lots. Now, speaking of how sensitive and how our area is over there, there's 29 houses behind us that use Pickerel Creek to access the lake. And I see these boats going in and out all day long. Now, they've been going in and out for decades back there, and the quality of the lake in the shoreline there hasn't changed one iota for the 21 years that I've been there. And nothing has changed from the time that I've been going there. So do we want to tell all those people back there on those 29 houses that have roughly 50 to 60 boats that traverse that area that they can't use that area anymore? Or do you just want to tell me that I can't use the area that is my shoreline there? So if we were truly doing anything detrimental, or they in the back there in the 29 houses were doing anything detrimental, there would have been a big crisis already, and we would have told all those people to stop using their piers and their property. Another thing, this nonsense about I cut the shoreline out there. The way the property is right now is exactly as how I purchased it. I didn't touch anything along that shoreline. If you go back and look at the history, the pictures off the GIS, where you go back 5, 10, 15, 20 years, 25 years, the shoreline hasn't changed one iota. So I didn't change that shoreline one bit. The attorney mentions that you have to really prove that you had boats on the shoreline. I am grandfathered. This picture right here, and I shared it with you guys already, it was in one of the previous packets. This picture right here shows a date of 8/1/2011. And that is just before the grandfathering went into effect. If you want to take a look at it, it's right here.
Well, you're gonna continue
Okay.
to talk to us.
Okay,
I'm
well-
not gonna tell you anymore.
Well, I don't want
Because we're not
anyone-
gonna sit here all night and have these arguments
Okay,
and
I
point
just want to
fingers.
make sure
So
that the
talk to
board
us, please.
knows what I'm talking about.
That's great. You have a photocopy of a picture that may or may not be dated in 2011. We've
Well,
seen it before.
Okay, it is dated.
Thanks.
So anyway, I just want to emphasize that I have the right to have 10 boats there, whether you like it or not. Okay, so it is what it is.
I can put that in my property.
We're not gonna have this discussion.
I apologize.
Thank you.
Okay, as far as measuring the shoreline, you measure the shoreline regardless of irregularity. You measure every inch of the shoreline.
And I don't think we have to discuss that
Well, I'm just.
What the actual weight is, because it's written down somewhere, and that's what it's gonna be.
Right. Well, I just want to make sure that the record is clear because certain people that got up here prior to me, just now, they stated that, the
But
shoreline.
if you're already grandfathered for 10 boats, who the fuck cares what the shoreline is, right?
Well, I'm agreeing with
Right.
you. That sounds good to me.
Okay.
All right.
Well, like, I don't think we need to adjudicate the number of piers that you do or don't have, and what you're here for is a conditional
Conditional
use for the
use.
marina,
Correct,
right?
right. And I'm trying to focus on that, but because a few people in the audience decided they want to come up here and throw some stuff under the bus, I just want to let the board know that the stuff they're throwing under the bus is irrelevant. Because,
Because we live there, what you do, excuse me, Robbie.
He's leaving.
okay. I'm just trying to let the board know that what we're doing there is going to comply with everything in the zoning code book, and that we are asking that the board takes into account Act 67 and follows what the code says. And I'm going to follow everything what the zoning book says, and that's why I feel that this conditional use permit should be granted, because it's state law, and it's kind of tough to beat state law.
All right, thanks. All right, any other discussion amongst commissioners?
Yeah. So there's a number of lawyers spoke today. There's an Attorney Mills wrote a letter, Attorney Cotter wrote a letter. There's conflicting interpretations of the law. I don't think we can look at the written statement of Michael Cotter or Attorney Mills or any of the attorneys present to dictate what we ultimately decide. Unless Michael Cotter has won every single court case that he's ever, argued in front of a judge, or Attorney Mills or any of the attorneys here, it's just not a record we can go off of. I think these things get litigated. I'm not an attorney. I don't think any of us are. Attorneys argue all this in front of a judge, in front of other attorneys. Judges sort these things out. So with that being said, my concern, and I'm hoping we can get some clarification around this, is do we need to apply both the C2 zoning code and the C4 zoning code to a marina application on a parcel that is split zone? It's very confusing to me. I think it's confusing to a lot of the attorneys. Another point I want to make is there's a lot of discussion around the use of the piers in a sensitive area. We haven't, as far as I know, this hasn't been submitted to the DNR for review, and I think if it's possible, I'd like to do that to get some direct input from the DNR on this application, and to see if the DNR has any concerns or suggestions that we can incorporate into our decision.
Agreed.
I think I'd like to follow up. I'd like to get some clarification on parking in C2. And I think we can review that in the zoning book.
Right.
I don't remember, I can't recall if we made a decision on the conditional use involving parking on the C2 in the past. So I think we should look into that as well.
Sure.
One more comment.
Certainly.
It was brought up that the marina permitting with the town board, town marina permit. I think we could get some guidance from Attorney Mills on that. That being said, I think it's probably pretty similar to a building permit in that we're not really issuing permits here, probably not really looking to decide on permits. I think we should stick strictly to the conditional use.
Agreed. All I was thinking is if we have a device where we issue marina permits, maybe that's part of the conditional use. Should we approve a conditional use?
Conditional on a permit, sure.
Correct.
Yep. So those are just some of my thoughts. And that's it on my side.
Okay.
So I think we're doing a good job identifying the additional information we need to make a decision. And another one I would say is a new wetland delineation.
Sure.
Which will tell us a couple of things.
And one from the DNR. It should be from the DNR.
Well, Sewer Pack, I believe, is the authority for the
Yeah,
wetland
and I refer
delineation.
to you, I think this was provided to the applicant during the zoning hearing, but I did reach out to Surback, and they provided some details on when that was done and things, and those are assured for a period of 5 years. So,
And it was
that's
in
expired.
2012, yeah.
So it's no longer, the delineation that's on file is no longer assured by Surback. And that, the period, full stop.
Mhm. Okay. Any other discussion amongst commissioners? Okay, thank you. Joe, you want to come back? Next item on the agenda is any other business amongst commissioners? I'll give you a second, Joe, you don't have to sprint. Then any other public comment on any other topics? If not, I would take a motion to adjourn.
I move we adjourn.
I have a motion to adjourn. Do we have a second?
Second.
All those in favor?
Aye.
Opposed? We're adjourned.